anticipated and much waited for Joint Judiciary Interim Committee meeting. Apologize that we weren't able to meet the other day. Logistically, we're still in a bit of a bind. The House is returning at 1 o'clock, Mr. Co-Chairman, so that puts us in a bit of a time constraint. So committee, I think here's what we're gonna do. You have, in your folders, you have a sheet that lets you rank the topics. We're gonna go through and take public testimony as efficiently as we can, and then you will need to complete your form and return your form to LSO today. So it doesn't have to be at the end of the meeting, but sometime today, get that form with your ranked topics to Brian, and then he's gonna put everything together, and then Mr. Co-Chairman and I will meet, and then we'll produce our letter to Management Council. But it's, in order for the timing to work on all that, unfortunately, we have to get that done today. So that's where we're at, and I think we'll just, if that's good with everybody, if there's no questions, we'll dive into public comment on these interim topics. Mr. Co-Chairman, please.
Thank you, Mr. Co-Chairman. So before you got here, I told the folks in the room that we might be shooting at no more than 2 minutes, a couple people tops, 1 minute apiece to expeditiously move through these.
It sounds like a wonderful idea. Thank you, Co-Chairman Washit. Okay, so do you want to go through these topics, or who do we have? Let's see, we've got Director Shannon. Is Alyssa here? No, we don't have anyone from the Supreme Court.
The other Alyssa.
The other Alyssa. Okay, well, let's just go through the list then. We'll start with the landlord rights concerning evictions. Representative Campbell. No, this is not you. This is Representative Brady. I'm reading it backwards. Representative Brady, would you give us just the short and skinny on what this is?
Yes, thank you. I think we have two online that are going to speak. We took advantage of the this topic opportunity. I'd like to them to, it's just to help support. We already have a problem with apparently housing shortages around the state, and this gives an opportunity for the landowners to hopefully get legislation, if we deem it necessary, to help them go through the process faster, to allow them to keep their rentals open rather than going through the process of court and things. So that's what that's about.
So let's go ahead and let in DeVries and Lockhart.
They're both online.
All right, welcome. If you can hear us, go ahead and light up your camera so we can see you, and then we can figure out who's going to go first here. All right, Mr. Lockhart, you're first. We cannot hear you. You're on mute.
On mute. Okay, there we go. Yes, I was informed of this yesterday, so I haven't had a huge amount of time to prepare. But if we could get an eviction process moving in a much faster fashion than what we have at this point. I don't have any particulars. I know Prune would have more ideas on that than I would, but I would definitely like to see something along those lines happen.
Okay, thank you, Mr. Lockhart.
You're welcome.
Thank you, Miss DeVries.
Yes, good morning. Thank you for the opportunity to talk to you. And Jim knows me by Prune, that's my nickname. Anyway, you have the packet that I submitted on it, and the problem that we're having is that it takes so long to evict somebody through the courts, and that gives them all that much more time. It took me 2.5 months to get a tenant evicted, and that gave him 2.5 months to do more damage to my apartment, to steal a lot of stuff that was in there. And I was not able to recoup rent or anything else or any of the fees, because we have to pay all the fees to have this brought to court and served and again and again and again. So we have no recourse to recoup that. And so we're just at a loss. And this has been kind of a bad year at my property anyway, because I'm pushing $50,000 in the hole because of tenant damage. And unless you've got 50,000 burning a hole in your pocket, it takes a while to, get that money together. And all the time that the units are down because they have to be repaired, that's one unit off the market that will not be available for people to rent. So it's a catch-22. We need your help, and we need some better legislation to cover the expenses and all of the thievery and damages that are done by tenants to landlords. And I very much appreciate your input on that.
Thank you, Prune. Any questions? All right, we really appreciate you. Thank you. All right, we'll move on to our next topic, foster care system. Now it's Representative Campbell. I can read the packet now. I figured out how it works.
Thank
And
you.
Representative Campbell, you've got two topics, so looks like we'll just take them one at a time.
Perfect. Thank you, Chairman, and members of the community committee. It's Friday. Thank you for this opportunity. In terms of the foster care system, this comes from a constituent, actually a few constituents, who are currently fostering kiddos, and challenges that they have been running into, and the unintended damage we may be doing. Part of the consideration, I think, is asking this committee to look at how we approach doing right by these kiddos. I think right now the emphasis is on reunification, and sometimes unintentionally that does more damage, depending on the birth parents, and that the long-term, I think, trauma that can occur with these younger kids, 3, 4, 5, 6. I think I included in the notes, I think Montana and their statutes has readjusted the framework. And so it's not just focusing on reunification, but also taking into consideration the kid's perspective and what might be best for them and in their best interest, and what that looks like, and actually adding more credibility or more weight to even these younger kiddos, 3, 4, 5, 6, in some of the very horrific situations that they may be in. We have agencies in place to get their testimony and secure their testimony. But in the foster care system, we don't, and don't rely on their perspective and their testimony as much. So the ask of this committee would maybe to take that up as an interim and really focus on the foster care system and what we have in place and where that emphasis is, and maybe balancing between the push for reunification and what is in the best interest of the child. From the parents in my community that reached out to me, the challenge really is with that reunification, it's listening more to the parents and maybe not as much the kiddo. So that is the ask. And I will try to answer questions, but I don't know as to how I am able to.
Yes, Representative Lane.
Thank you, Mr. Chairman. Thank you for bringing this before us. I'm just curious if you also submitted this to Labor Health and if they've had a conversation about visiting this or not.
Representative Campbell.
Thank you, Mr. Chairman. Representative Lean, I did not. I wasn't sure where it would be best situated. If this was more through the court and, foster care part of that, or through Labor Health. I'm happy to, realign if we need to.
Senator Kolb.
Yeah, thank you, Mr. Chairman. Representative, how large of an issue is this? I mean, a lot of times we get, well, I know everybody thinks it's, a huge thing sometimes, but really statewide, what other information do you have that points towards it being a larger issue than saying maybe, and frankly, sometimes folks are disgruntled because of how something didn't turn out the way they liked, and that kind of comes predominant in the conversation. But in a broader sense, what other information can you bring about why the rest of the state or the larger picture on why it's necessary? Thank you, Mr. Chairman.
Representative Campbell.
Thank you, Mr. Chairman. Through you, Senator Kolb. That is, I think, one of the reasons for this ask. Oftentimes there are missing pieces within the system that we're not aware of until a constituent brings it to us. I will reference, just the stalking legislation that we signed the other day. So while I've had 3 or 4 conversations with fostering families in my county, I don't know what that looks like statewide. And I think that's the question we need to ask, because I would imagine there's more out there than we're aware. And that would be part of the purpose of this assessment, I think.
All right. Thank you, Representative Campbell. You have another topic for us, the Blue Envelope Program.
I do. Thank you, Mr. Chair. So this also was brought to me from a constituent, not in my district, and wasn't on my radar, and now it is. And so would bring this to your consideration, and to speak more to this topic, I would defer. I think we have Lieutenant Como online from Sweetwater County Sheriff's. So if we could bring him in, and then I will defer to him.
He's online.
Welcome.
Welcome. Morning, committee. As Representative Campbell kind of introduction, my name is Richard Como. I am with Sweetwater County Detention Center. I'm a lieutenant here. I'm also a part of the advisory board for the National Autism Safety Council. And most importantly, I am a father of a teenage boy that is autistic as well. And Representative Campbell might have to jump in a little bit on this, on the exact understanding of the Blue Envelope Program, but it is my understanding that it is a functionality to where individuals that are on the autism spectrum, or even maybe some that have some cognitive or inabilities to communicate with interactions with law enforcement. I know I got a short time. I got tons to say on this. I'll keep it as brief as I can. Like I said, most importantly, I got into the interactions with law enforcement and individuals that are on the autism spectrum disability is due to my son directly. I've learned a lot over the years, and there is a lot. If somebody just Googled in law enforcement interactions with individuals with autism that ended badly, you will come with a plethora of incidences that have occurred. And there's some that recently have happened close to here in Wyoming, closer to Sweetwater County in the states of Idaho and Utah, that really hit home with me. And I think this type of legislation, this program, would be great to implement in order to exchange information, to be able to communicate, because some of those individuals on the spectrum are socially diverse. That's one of the things on the spectrum, has a hard time in social situations, specifically in emergencies or encounters with authority. And then I guess the other aspect to it is it helps build a positive interaction for first responders, law enforcement with these individuals. Again, I know I'm kind of limited on time, and I'd gladly sit down and discuss this in further detail. And at this point, I'll stand for any questions.
Senator Kolb.
Yeah, thank you, Mr. Chairman. Deputy, Is Sheriff Grossnickel in agreement with you? I didn't hear if he thought this was a good or bad idea. Could you shed some light on that, please? Thank you.
Mr. Como?
Yes, Chairman, Senator Kolb, I haven't had a chance to sit down with Sheriff Grossnickel. He's been away this week. Again, this is something that just came across my table as both a parent and in the law enforcement spectrum. And so I haven't had a chance to sit down to have a good discussion with him about it.
All right, well, thank you, Mr. Como. I know you have a lot more to say on this. I think it's a wonderful idea. If it moves forward, we'll definitely be spending some time together this summer.
Sounds good. Thank you.
If I may.
Yes, Representative Campbell,
Thank
please.
you, Mr. Chairman. So a little background just quickly on, this is a national program, the Blue Envelope Program, and it is exactly, I mean, as Lieutenant Como described, provides not only, I mean, internally, our police departments, sheriff's departments, so internally providing them with materials, and as far as training and curriculum, how do we best navigate these situations? They are unique, especially when we have those drivers who are on the autism scale. So it helps inform and train our law enforcement officers for those interactions. And then the blue envelope comes from a sticker or a decal that can be applied to a window that just gives law enforcement heads up, right? This is the situation. And then also, I mean, can include a blue envelope that is on the dash of the vehicle that includes all of that really critical information from license and registration and insurance, emergency contact lists. All of that is in the blue envelope. So it just helps really smooth out the interactions between our individuals, our residents who are on the autism, spectrum scale, and law enforcement. So it's a much smoother interaction. Gives both tend to be a little better equipped with those situations. And that would be the goal, to have this as statewide, so we do have that communication and consistency throughout the state.
Great, thank you, Representative. Appreciate you. Next, we have Senator Case or Mr. Howman. Or anybody else on sentence reduction, clean slate? No? Going once, going twice? Okay. The next one, we've got several individuals. Representative Connolly on felony charge for repeated dangerous driving, aggravating factors. And then I think, do you have somebody online or?
Page 6, yeah,
Who do you have online?
Kate Gladden will be.
I don't have her on my list. Is she, can we see if she's online? I thought they were the same, they're the same topic though.
Yes, sir.
Yeah, but I'm saying she's not on my Zoom list. Do we have her, Pierre?
Mr. Chairman, she's under the third category, under Michael Cusick.
I stand corrected. Okay, go ahead, Representative Connolly.
Mr. Co-Chairmans, I'm here today to ask that the Judiciary Committee take up the topic of a really serious issue that I think has fallen through the gap on homicide by vehicle. This would be to study Wyoming Statute 6-2-106. And this deals with not being able to charge. The way that the law is written, there's a gap with how to consider prior DUIs, high-risk drivers, and so on. And what I'd like to do is allow Ms. Kate Gladden to give her brief testimony on why this really needs to happen, if that's all right.
All right, Pierre, let's let Ms. Gladden in. Thank you, Representative Connolly. Oh, she's already in. Hi, welcome.
Good afternoon, Mr. Chairman and members of the committee. I just want to express gratitude to Representative Connolly for sponsoring this topic, and to Senator Crago and Representative Kelly for their time in discussing this with me. My name is Kate Gladden. I'm a resident of Sheridan, Wyoming, and I'm also the daughter of Julie Fitzsimons, who was killed May 28th last year while legally crossing a marked crosswalk in downtown Sheridan. The driver who killed her had a prior DUI from recently crashing his vehicle, was on probation at the time for domestic battery and evading law enforcement. He has 3 excessive speeding convictions, including up to 97 miles per hour, and he was driving under an SR22 because Wyoming had already formally designated him as a high-risk driver. Yet the moment he took my mother's life, all of that became legally irrelevant. I still remember the police officer sitting opposite us at the station that day, feeling defeated, saying, "We're charging him with vehicular homicide, but I'm sorry, it's just a misdemeanor." See, unless you're intoxicated at the time or driving in a way, as one prosecutor put it to me, at 100 miles an hour down Main Street while the police are chasing you, killing someone on our roads in Wyoming is automatically otherwise a misdemeanor, regardless of the history. Yet driving is a patterned behavior, and prior violations are one of the strongest predictor of future crashes. Yet our law treats every fatal crash as if that history simply doesn't exist. So I'm not asking for mandatory felonies, just prosecutorial discretion when aggravating factors are present, such as a prior DUI and documented dangerous driving. I'm grateful to be working with Wyoming Pathways Executive Director, Mike Cusick, who will share more with you shortly on the broader issue of this throughout our state. I guess I want to say though, while this gap remains, repeat dangerous drivers who take a life on our roads face more than a little slap on the wrist, which leaves no accountability, no deterrence, and I can assure you, for families, no closure and no sense that the law recognizes what was taken. I know it's too late to save my mother's life, but it's not too late to take action in her honor and to turn this loss into legacy that helps make our roads safer for all Wyoming families. Thank you for your time. I welcome any questions.
Ms. Gladden, thank you for joining us. We deeply empathize with your loss, deeply sorry for that. I'm glad that you are taking a role as an advocate and advocating for change. That's not necessarily the easiest thing to do, so I really appreciate you. I want you to know that I've been on Judiciary for some time now. We have studied this topic before, so it's not entirely a new concept to this committee, but at least to the members on here, it will be newer to some of them. But this is definitely something that's been on our radar for a while, and it is a gap in Wyoming law. Co-Chairman Washut.
Thank you, Mr. Chairman. I just want to note that Ms. Gladden is joining us from Australia, where it's 6 o'clock in the morning.
Yes, I am. Yes, I am. But yeah, we're actually hosting a memorial concert for my mother this weekend, so that is why I'm in Australia at the moment.
Well, thank you for taking your morning with us.
Absolutely. Thank you all for your time.
And we have Michael Cusick. Pierre. Welcome, Mr. Cusick.
Good morning, Senator Olson, Chairman Olson, and panel. Michael Cusick with Wyoming Pathways, based here in Lander, Wyoming. We serve the entire state of Wyoming to help make towns safer for bikes and pedestrians. Our concern in this issue is not just Kate's tragedy, but other incidences around the state, including young people. We all sadly remember the young boy who was run over on his way to McCormick Middle School years ago. There's a not-for-profit formed around improving that situation for other kids by his mom. Here in Lander, we had a young person hit in a crosswalk going to school by someone who was turning right on red, and the sun was in their eyes. And I don't know that there was any serious sentencing there. And the young gal had many surgeries and has some loss of function because of that. And when I talk with those parents, they're just like, what in the world? How come this thing's like a traffic violation? So some of the things we've done to this point, we've sent a letter to all 23 county attorneys. We've heard back from them that they're interested in discussing this with us and partnering on it with us where they can. They agree that there's opportunities here. Essentially, what we're asking for would be consideration that this just be a tool in the toolbox. When incidences like the one that Kate endured and many others have endured, whether the person was injured or sadly killed, there is no option unless we have those other circumstances. And I feel like we have way too many folks running around in their cars with their phones. We see it all over the community where I live here in Lander. And I think that we need to send a message that people in a crosswalk in particular, that's a protected space for pedestrians. We have statutes for that. There should be an absolute guarantee of as much certainty as possible. And I think by having the option of charging it as a felony, we send a message to drivers to be extra vigilant when they're driving through those types of zones, especially as in Kate's case, middle of the day, downtown Sheridan. It's absolutely galling to me. And every time I hear about one of these, we want to keep working harder until we can make the state safer for all pedestrians, bicyclists, and drivers. And I'll stand for any questions.
Committee, any questions? Mr. Cusick, thank you for joining in. We appreciate your testimony.
Thank you for the time.
All right, thank you, Representative Connolly. And Senator Crago, this is also a topic brought to us equally from Senator Crago, so there's a lot of interest in this topic. Okay, Senator Cooper. Senator Cooper, there you are. Thanks. We've got campaign finance reform. Go ahead, Senator.
Committee, good to see you here today. Ed Cooper, Senator District 20. I'm here to talk to you a little bit today about dark money and the dark money resolutions we've brought forward in the last couple of years. A year ago, we had one, Senate Joint Resolution 8, passed it out of the Senate in great shape. We ran out of time on the House. This year, with the introduction, we didn't quite get Senate Joint Resolution 2 introduced, but both of them addressed the issue of dark money across the nation. And the point of the resolutions is to ask, is basically to bring it to light as much as anything. But the resolution asks our delegation in Washington, D.C. to start the process of seeking a constitutional amendment to allow us to override the Citizens United rulings that have severely curtailed states' rights to control and monitor spending on elections within our states. That ruling several years ago has stripped the states of their ability to really even track where the money coming into the states is actually coming from. I don't think anybody on this committee thinks that foreign money or some of this dark money is good for our elections. The influence of it is just almost insurmountable at times. I'm not sure why groups out of Washington or Virginia or Texas are so interested in controlling our elections here in Wyoming, but they sure have got involved in the last few years. So in June, I believe it was, we went to DC and talked to a Republican House working group about this issue, and it was very well received. I think most people back there understand the issue, and they're ready to start working on moving forward. 24 states, I believe, have passed a resolution of this type so far to try to bring this to light. And it's a serious problem. It's a problem that needs to be addressed, and this is the committee to address it.
Any questions for Senator Cooper? The only question I have is, did you also submit this to corporations and elections?
And no, Mr. Chairman, we did not. But that's not a bad thought. In the past, it's came through judicial. So that did 2 years ago. I don't remember where it went this year.
I think it did 2 years ago.
Yeah. Okay.
Okay. All right. Any questions for Senator Cooper? Thank you. Mr. True? We have amendment to statutes defining peace officers, Wyoming Livestock Board. Welcome, Mr. True.
Good morning, Mr. Chairman, committee. Thank you for this opportunity. Our agency would like to ask to put before this committee a review of the empowering statutes of our investigators in the peace officer definitions. Want to make clear up front, I'm not asking for expanded authority or more duties for them. The two guys are pretty busy, but we would like to maybe add something similar to what's in Game and Fish about offering them the ability to act on a felony that occurs in their presence while they're doing their normal duties. That's not allowed currently in statute. Neither is a public safety opportunity to protect the public from imminent bodily harm in the event of that, seeing a felony like that. That's what this whole request is for your review, so we get that right and discuss any options that you may wish in that process.
Co-Chairman Washit.
Thank you, Mr. Co-Chairman. Mr. True, would you expect the Livestock Board investigators to complete the Wyoming Peace Officer Basic Academy in order to achieve this status, or do they already complete the Peace Officer Basic?
Mr. True.
Mr. Chairman, Co-Chairman Washit, both of my officers are post-certified. Both are longtime law enforcement officers, also certified firearms trainers and certified active shooting trainers. So they are fully vetted law enforcement officers.
Any other questions, committee? Just so you know, kind of my thoughts on this topic, for those of you who may not have seen this, a few years ago, we added Game and Fish similarly, or not, parks. We added state parks, and if we were to take up this topic, it would be my recommendation that we kind of take a broader approach and think about if there are any others that should be included in this. So every couple of, because we're not just going to have the same repeat conversation just with a different agency. So if you're interested in it, just be thinking of it kind of more broadly. Who else can we include and have the conversation as a whole? Thank you, Mr. True. Next up, we have Brenda Manina Mongold or Representative Lean. You can stay there if you'd like.
Thank you, Mr. Chairman. I'll speak to this. We're just asking for a review on the non-disclosure of the public-private partnerships for executive sessions. Not that executive sessions come out mostly to review NDAs. For instance, there's some municipalities and counties that are taking up NDAs and for industries that are coming into Wyoming, but at no point does our statute say that these need to become public records. So the public's never enlightened on what that is, whether it's a time frame that we say 10 years down the road or 3 years down the road or what have you, so that the public has a clear understanding of how this process was executed. And that's what the review of the statute asks for.
Any questions for Representative Lean? All right, thank you, Representative. Next, we have Senator Pearson. And you have, it looks like a witness online, Mr. Murphy.
Mr. Murphy is not online.
He's not online? Okay, well, we'll hear from Senator Pearson.
Thank you, Mr. Chairman, co-chairman, members of the committee. This year I brought SF 93 shared custody amendments, which failed introduction by 2 votes. I'm asking this committee to consider and take up this topic of shared custody on a temporary basis in the event of a separation. This is the first step to provide our citizens, our fit moms and dads, who deeply desire being a part of their child's life, the opportunity to do that without fear. Families have been torn apart by endless litigation, drained savings, and children caught in the crossfire. Colleagues, let's give families a fairer start and our children the love of both parents from day one. Thank you.
Senator Pearson, just hearing what you said versus what's on paper, is your intent to limit this discussion to temporary orders of shared parenting or permanent orders of shared parenting?
At this point, Chairman, members of the committee, I just think we have to do something, and I would like your committee to consider this as an interim topic. In the end, yes, I would love it to be, permanent, but we have to start somewhere. So if our committee can discuss this as temporary, just to see if this works for parents and families and our children across the state, I'm amenable to that. So I know we have to start somewhere, and this year we got Shared Parenting Day passed, so that was a win. But there are a lot of parents in our state and a lot of children that are caught in this. And I just think that if parents who are willing and who are fit parents, that's what I'm addressing here, are able to have the opportunity and not the fear that in a separation, that they're gonna lose their children, that they're gonna lose that connection, that they're gonna possibly not be able to be with them from day one of that separation, So I'm amenable to whatever the committee would decide, but I just think this is a very important topic. And I would appreciate your support. Thank you.
Thank you, Senator Pearson. All right, no questions. Thank you. All right. Next, we have Representative Storr. DUI penalties, refusal of a chemical test.
Thank you, Mr. Chairman, Mr. Co-Chairman, members of the committee. Great to be here at Judiciary. I haven't had a chance to spend much time with you. So last June, on a Saturday afternoon, a beloved member of my community was struck and killed while bicycling. And the driver was driving 92 miles an hour in a 35-mile-an-hour zone, crossed the lane to the lane of oncoming traffic and struck her at about 63 miles an hour, killing her instantly. Not knowing that much about how our laws work for DUIs, I talked to our county attorney just to see whether there was anything we could do to strengthen our laws that would have altered that event. I don't think there was. That driver actually didn't have a prior DUI, but the prosecutors really argued the case that it illustrated how a single impaired decision can alter countless lives, really. So in visiting with the county attorney and law enforcement, I do believe we can strengthen our laws such that the consequences of driving and drinking are enforced as intended, and that such treatment is mandatory upon an initial DUI test. So I brought HB 192 this session to address the issue that more drivers are actually refusing a chemical test after being arrested and a warrant is obtained, resulting in the likelihood that their DUI charge actually would not hold up in court. So in some counties, when someone's arrested on probable cause, that means that the driver sometimes is held down against his or her will in order to obtain a blood test. In my county, we don't do that. We just end up charging them with interference of an officer. And as a result, there is no test, which means that DUI often doesn't even go to court because they just don't have the evidence. It seems to me that neither of those scenarios is optimal. So in talking with my county attorney, we came up with the idea that we could strengthen our laws by refusing a test had the same consequences of an initial DUI, and that's what HB 192 did. It was not introduced over in the House, but I think it warrants having some discussion here. It would require treatment, ensure a minimum 30 days of license suspension, and make any subsequent DUIs carry the penalty our laws intend. This will help ensure that an initial DUI is truly a wake-up call for the driver arrested, and make it clear that Wyoming takes drunk driving seriously. I also just, in visiting with numerous attorneys and law enforcement, I do think that our DUI statutes have been amended so many times that there's a real lack of clarity there, and it may be something that you all could take on in order to look at some revisions overall that might be in order. Thank you.
Any questions for the representative? All right, thank you, Representative Storr.
Thank you.
Co-Chairman Washit, review of statutes relating to political parties.
Thank you, Mr. Co-Chairman. See Mr. Schriftman's name there. He and I had a brief conversation a while back about this topic. I suppose that's why my name got attached to it. I don't have a lot to say other than our political parties are identified in a number of places in our statutes, and I think Mr. Schriftman was looking for a broader discussion of should they be. Should we involve our political parties in various processes of replacing absent people and those sorts of things. So that's the topic.
Any questions for Co-Chairman Washit? All right, thank you. Ms. Butler.
Good afternoon, Mr. Chairman, Mr. Co-Chairman, members of the committee. My name is Elise Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. The topic that we've requested for interim review is around remote public access to court records. And so this is something that has come up frequently over the last few years as we've begun to move forward with our court automation systems like e-filing and some of the other pieces. And this has become a topic that we hear about quite frequently from the public, from attorneys, from legislators. And so we would request this interim topic to review essentially where we're at as a branch of government in moving toward remote public access. It is something that's currently on our operational plan. So it is something that is in the works right now. The steps that need to be taken, some of the policy decisions that need to be considered, including how to retain the privacy of some of the citizens who appear in our courts, and how to thoughtfully do that moving forward. And the last thing, of course, is always the funding required to move toward a remote public access system. So, Mr. Chairman, that is essentially what we're requesting, and I'd be happy to answer any questions.
Any questions for Ms. Butler? And committee, just so you're aware, I think everyone's been through this process before, but we take updates from our agencies as well as from the third branch of government. We'll do that in our first meeting anyway. So lots of ideas might spring from that, including not limited to this, but other ideas. So just be aware that we will invite them in, and we always do that. And see, there's always bills and work that gets produced from that. No shortage there. Thanks, Ms. Butler.
Thank you.
Title VI, Co-Chairman Washit wants us to review the entire title. Sounds exciting.
Thank you, Mr. Co-Chairman. We frequently adjust penalties for various crimes because of political interest or popular efforts to change our minds. And, like we just talked about the, driving distracted and leading to death, right? The vehicular homicide. So we often modify our statutes. What I'm asking is that we go through our criminal statutes, especially the felony statutes, and make sure that the penalties relative to one another make sense. It is not going to be a simple task. I think it would be fairly time consuming, but with good LSO support, I think we could look at that, think about different strategies. Some states have Class A, Class B, Class C felonies. We may want to go somewhere along that line, or some other approach. But just to try to make sure that we don't have a penalty in one case that seems much more severe than a crime which we would consider more severe over here. So that would be my goal. It would not be a light lift for the committee.
All right, any questions for Co-Chairman Washut? All right, thank you. Ms. Semino, child abuse criminal statute reform. I've seen this one before in my lifetime on Judiciary as well.
Mr. Chairman, members of the committee, I will do my darndest to be brief. My name is Lindsay Semino. Though I usually speak to you representing the Wyoming Behavioral Health Alliance, today I am speaking as a Wyoming mom. In 2015, my 3-year-old son was physically beaten at a licensed daycare and sustained injuries that lasted approximately 2 weeks. As a mental health professional, I knew all the proper steps in reporting and how to handle law enforcement. Though DFS substantiated abuse and the detectives recommended felony child abuse charges, in the Laramie County DA did not feel as though he could press charges against the daycare worker due to the vague and open-ended language of Wyoming's criminal statutes and definitions regarding children. Finding this unacceptable, I squatted in the DA's office, refusing to leave until the DA agreed that he would charge the daycare worker with something. Eventually, the daycare worker was charged with misdemeanor simple battery. At sentencing, the judge stated that he also did not understand why this case was not in felony court. Over 10 years later, these statutes and definitions remained unchanged. I am requesting for the committee to consider criminal reforms which would develop a tiered classification system for child abuse charges similar to neighboring states such as Idaho, Nebraska, Utah, North and South Dakota, and Colorado. This would permit the justice system to use its discretion on offenses that are not currently being charged. It would also send a message of Wyoming's commitment to protecting its children. Because these statutes have not been reviewed for several decades, this topic has the potential to produce multiple bills, including a separate tiered classification for physical abuse, neglect, and aggravating factors, as well as updating definitions in Title 14. I have prepared an executive summary for the committee as well as an appendix for reference. With the successful passage of House Bill 8 and 9 this year, it now feels like the most opportune time to have this conversation again. This is not the first time I've proposed this topic, but I'm hopeful it could be the last. And with that, I stand for question.
Any questions for Ms. Semino? That was speedy, thank you, we appreciate that. And we've got your materials. Ms. Parrish on review of Wyoming mandatory reporting laws. Oh, no. You're not Ms. Parrish.
Mr. Chairman and members of the committee, my name is Lynn Story-Heiler. I'm here on behalf of Jewel Parrish. I'm the chapter president of the Child Advocacy Centers of Wyoming, and she couldn't be here today because of some snow issues, so I'm going to represent. We respectfully request that the committee consider an interim topic focused on reviewing and modernizing Wyoming's mandatory reporting laws relating to child abuse and neglect. Mandatory reporting is one of the most crucial safeguards we have to protect children. However, questions continue to arise regarding clarity of reporting thresholds, consistency in application, training requirements for mandated reporters, enforcement mechanisms, and alignment with multidisciplinary practices. A comprehensive interim review would allow stakeholders to evaluate whether current statutes provide clear guidance, adequate protections for reporters acting in good faith, and effective coordination between schools, child protective services, law enforcement, and child advocacy centers. Additionally, it is important to examine enforcement provisions when individuals who witness or reasonably suspect child abuse fail to report it, resulting in continued child abuse. A review of accountability measures, consistency of enforcement, and whether current penalties serve as an effective deterrent would be valuable in ensuring the statute fulfills its protective purposes. And I stand for any questions.
Any questions for Ms. Story-Heiler? All right, are you covering her other topic as well?
I am.
Let's jump to that one. Adding multidisciplinary investigative teams for child abuse cases.
Yes. Again, Mr. Chairman and members of the committee, we ask that you look at the multidisciplinary investigative teams for child abuse investigations. So Wyoming is kind of confusing in how we determine how a team can function in the area of child protection. Most other states are able to convene multidisciplinary teams and discuss cases and work them collaboratively so that no entity is working in a silo. Unfortunately, Wyoming has some restrictions in terms of MDTs or multidisciplinary teams are already in statute, and those are specifically for children who are in the care and custody of the state of Wyoming. They're in statute, and it says who will be part of that team. So when we try to do what is best practices, multidisciplinary teaming of child abuse and neglect cases is best practices across the nation. When we try to do that, we have some barriers in order to do that. So we're asking you to take a look at improving what we already have. We do have good child protection team statute, but it's kind of inadequate for what we're needing for teams. What happens is the language in the CPT is really kind of not specific for what our partners need. To be on a child protection team, you can be a member of the county government. Who is that, in terms of child protection, investigating child abuse? It can be a city and town in the county. Again, who is that? We're looking for and needing specific disciplines to be on those teams that are investigating child abuse and neglect. Those are our law enforcement partners. That's our prosecution. That's our medical, our SANE nurses. That's our child forensic interviewers. That's our victim advocates. And so we're just asking that we take a look at the child protection team statute as it is written and see if we could add MIDT, multidisciplinary investigative teams, and if we could just kind of bring that up to where the rest of the country is in working. So, and I stand for questions.
Co-Chairman Washut.
Thank you, Mr. Co-Chairman. And can you recommend a state that has a particularly good statute that we might be able to look at as a model?
Absolutely. Absolutely. Sorry, Mr. Chairman. Idaho has a great one, and our neighbors to the east, Nebraska, also have a good one. So we do have some states that already have these in statute. We could model and look at those.
Great. Thank you.
Thank you.
Jumping back on your packet to Representative Pendergraph. Pay for judges, prosecutors, defenders. I know he sent something to you, Co-Chairman Washut.
Representative Pendergraph apologizes. The Appropriations Committee is busy. He couldn't be here, so he asked me if I'd speak on this. Just looking for a system that we might be able to put in place to make sure that our judicial salaries don't lag behind. Currently, we designate this a fixed dollar salary in statute. And might there be a possibility to set some type of benchmark that would create periodic pay raises for the judicial branch? That'd be the consideration.
Any questions for Co-Chairman Washut? No? No extra testimony on this one, Ms. Butler? Yay! Yep. I figured that much. Okay. Next committee, we have airspace ownership by Mr. Moline. He's online. Welcome, Mr. Moline.
Thank you, Mr. Chairman. Can you see and hear me all right?
We sure can.
Okay, thank you. I appreciate this opportunity. I know the ownership of airspace has been something that the legislature has looked at before. We've never really come up with any resolution. One of the concerns for landowners is what is their rights with drones flying over? What can they do? I think having at least an informational session on what are the rights of landowners, what are the federal laws that are in place, and then the next step would be, does Wyoming need to improve their trespass laws to incorporate drones? What what rights does a landowner have when has a drone flying over his property without permission? With that, Mr. Chairman, I'd sit for any questions you or the committee may have.
Thank you. Any questions for Mr. Moline? Yes, Co-Chairman Washut, go ahead.
Thank you, Mr. Co-Chair. Mr. Mullane, are you aware of any state that has effectively dealt with this question, and we could maybe look at a model?
Mr. Moline?
Mr. Chairman, Chairman Washut, not to my knowledge.
That gives us a great starting point. All right. Any other questions, committee? Thank you, Mr. Moline. Judicial deference, Representative Webb.
Thank you. I think Mr. Jackson is online for that.
All right, let's bring Parker Jackson in. All right, welcome, Mr. Jackson.
Good afternoon, Mr. Chairman. Can you hear me?
We sure can.
Great. I'll be very brief. I'm speaking today on behalf of the Goldwater Institute. We'd like the committee to take another look at the bill that was introduced by Representative Singh this session, House Bill 66, that would have dealt with judicial deference to administrative agencies. As you might remember, in 2024, the U.S. Supreme Court struck down what was known as Chevron deference in federal court when there's litigants that are facing administrative agencies. But that rule has not been codified or put solidly into the case law in Wyoming. There's about 18 states or so that either through legislation or through judicial decisions have done the same thing. And so House Bill 66 would have dealt with that. We think it's an important enough issue that this committee should take a look at it and hopefully sponsor that for next session. The state of the law in Wyoming is just inconsistent. Sometimes the court has said they defer. Sometimes the court has said they don't defer. All this would do is codify that same principle that the U.S. Supreme Court said in Loper Bright into statute. That's all I have on that, unless there's any questions. If it's appropriate, I'd like to also say a quick word about anti-SLAPP, if that's okay, Mr. Chairman.
Yeah, any questions on judicial deference for Mr. Jackson? No. And well, the anti-SLAPP topic is, I am bringing that topic. I apologize for not having it submitted, but it was on our Senate radar. It's a bill that passed through the House, came to the Senate. We felt like the bill as drafted was not ready to move forward. Senate has twice reviewed that legislation, once previous year, again this year. But it is a topic that we want to take up and we want to do it the right way. We just haven't, the bill that was brought to us just wasn't the right vehicle, unfortunately. So, I'm submitting that topic right now. Mr. Jackson.
Yeah, just again, real briefly, Wyoming's one of now only 11 states that doesn't have some sort of anti-SLAPP protection on the books. All that means is it's trying to prevent strategic lawsuits against public participation, or when somebody tries to abuse the legal process to silence somebody else's speech or curtail some of their other constitutional rights. And so it really just creates a mechanism to get rid of frivolous lawsuits quickly, and then also to provide a cause of action if there's damages and allow for recovery of attorney fees. Everybody in the room on the committee has now heard the story of Ms. Kari Cochran that the Goldwater Institute was involved with. So this is a pressing issue. It's one that's affecting real people in Wyoming now, and we think it's a great time for the committee to take it up during the interim.
Any questions for Mr. Jackson? All right, thank you.
Thank you, Mr. Chairman.
We've got, looks like the House is gavelled back in, but we have two topics, guys. So if we can just get through those, Director Shannon, amendments to 7-13-402.
Mr. Chairman, committee members, I'm Dan Shannon with the Department of Corrections. I would ask for your consideration for a review on how we address individuals that are in our Adult Community Corrections Center that abscond. 7-13-402 states, a prisoner is not eligible for parole if he's on sentence while serving a sentence, has made an assault with a deadly weapon upon an officer, employee, or an inmate, or attempted to escape from an institution. 71812 addresses escapes from an ACC. Our Adult Community Correction Center, we have 190 contracted beds, and what it does, it permits inmates to transition and reentry back into community instead of coming straight from prison. 718.112, an offender or parolee or an inmate is deemed guilty of escape from official detention if he or she leaves the place of employment or fails to neglect to return to an adult community correction center. In the past, it was automatic ineligibility. Our current parole board, which I respect, and certainly Director White, they review an escape as someone who's been criminally charged and found guilty. And then hold an evidentiary hearing. With that being said, there's a lot of factors, meaning these individuals will often ask for jury trials, things of that nature, where county prosecutors may not want to go down that road. So here's the statistics. In 2024, we've had 25 inmates escape from Adult Community Correction Center. 10 have been convicted, and 1 currently has a detainer. Of the remaining 14, they have not been ruled ineligible. We're not talking about people that have been late 1 hour returning back to the Adult Community Correction Center. On an average, they average 24 days on a run. I'll issue a warrant, and we catch most of them. What I don't know is what additional victims these individuals have created. Why 713.402? By administrative procedures, currently with the governor's good time rules, my office has the authority to flatten people. And what that would mean is they would never have an eligibility for overtime. In my 20 years with our department, it hasn't been used prior to me. I used it one time in 6 years. I think that's too excessive. So I don't think that's the road to go. But I would like to note that if an inmate goes to an inmate is eligible at this time to go to an ACC 2 years prior, before they're even eligible. And what this would prevent is an inmate that comes back from an escape automatically is getting paroled, not on the street. These individuals were sentenced for felony convictions under supervised and controlled settings and committed additional acts. To me, this is someone who's not ready to return to our communities and is a public safety risk. I would anticipate very little time in this committee, and it would have not an impact on the board, and I would not submit a fiscal note. Thank you for the consideration. I stand for questions, Mr. Chairman.
Any questions for the director? And House, you're just on enrolled acts right now, so to bring your blood pressure down, you're not missing much. All right, thank you. All right. Last topic from the Wyoming Trial Lawyers Association, we have reviewing fixed monetary amounts and possible changes to the structure for how the amounts are applied in the Wyoming Governmental Claims Act.
Good afternoon, Mr. Chairman, members of the committee. I'm sure most of you are quite familiar with this topic. It has been an interim topic of Judiciary in the past. However, no legislation has yet been passed. And even since this legislation has not been passed, we've had a member of the legislative body, Representative Smith, have a tragedy in his own family whereby these limits that are currently have been frozen since 1979 are not going to be providing adequate compensation to members of his family for a negligent accident that occurred and affected his nephew greatly. Those minimums right now stand at $250,000 for an individual and $500,000 for an occurrence or event. Just looking at inflation, we're well over 1 million for an individual and 2 million for an event. House Bill 62 that Representative Smith brought this session, that is exactly how it was brought. It was a simple bill that simply looked at raising each of those amounts to 1 million and 2 million respectively. However, this legislation has continued, I think, to not pass due to opposition that is being had against it for costs of insurance to governmental entities and their concerns about that. And our request from the trial lawyers is simply that as we continue to not pass any legislation, Wyoming citizens continue to not be fairly compensated or fairly treated. And these accidents and things are going to continue to occur just like occurred to Representative Smith's family. And so we would like this to be brought again in an effort to potentially find some solution. If the solution is not exactly what House Bill 62 was, then is there something else, and is there a compromise solution here in order to help Wyoming citizens in these situations?
Questions for Ms. Lance? All right, thank you.
Thank you.
All right, committee, that is everything we have. Is there anything else any other committee members have that you'd like to propose, Representative Lee?
Mr. Chairman, I know that the gaming is looking for a home committee, and I just wondered if this committee might be a good fit for it, as the Judiciary did hear quite a few of them, and 4 of the select committee members are on this committee.
We have the Select Committee of Gaming inside the Judiciary Committee. Sounds like it could be fun. All right, anything else, committee? Yes.
Mr. Chairman,
Senator
I think we ought to take a look again at this books and libraries and see if we can come up with a common solution that might work for everybody on that.
Okay. Anything else, committee? Senator Kolb.
Yeah, thank you, Mr. Chairman. I'd like us to look at felony interference with the police officer. I think the way that bill was worded was just really difficult to really understand how it interplayed with that issue. Mr. Chairman, thank you.
Yeah, what was that bill again? Senate file.
I don't have the bill number, Mr. Chairman.
Okay. All right. Anything else, committee? No. All right, you've got your sheets, do your rankings, turn them in to Brian, and then we'll take it from there.
I would mention
Co-chairman, go ahead.
It is possible that co-chairman and I will blend some of these together. For example, we had 2 or 3 that were somewhat related on child abuse topics. So it's possible that we can blend more than one topic together.
All right, we are adjourned.